The plaintiffs are looking to add additional claims and state laws claims in the case, which all of the defendants are opposing. And so that's being briefed for the court right now.
Okay.
Before we move on, I do want to give myself credit for not making a batten down the hatches joke for the Batten case. And now we can transition to the next question.
You're such an idiot.
I know.
Love you, though. You talk about it privately. We talk about it publicly. This is the Real Estate Insiders Unfiltered Podcast. Welcome to the Real Estate Insiders Unfiltered Podcast 2025. I'm your host, Dewiggy.
What up, Dewiggy?
What up? It's 2025. The world changed, my friend. Everything's different
go.
one day later, right?
Not the same, but oddly the same.
Let's talk about this one because we wanted to start the year off with a bang. So we had Lesley Muchow, the general counsel for the National Association of Realtors.
Yeah.
2-part pod.
Yes, and this is part one.
Part one. Tell everybody what we talked about so they'll want to be listening for both.
Yeah, so listen, kids, there's been a lot of confusion out there. This is our attempt to pierce the fog and create some clarity for you all. And we went right to the source. So we talked about where we are in time and space today with the class action lawsuits, the approval, the appeal, the DOJ statement at the final hour, and what all that means. And then we really dug into specific best practices and answers to many of the general questions that we receive from folks inside our company, that we see all around.
Yeah,
and people are really searching for, like, what's the right way to do it? So we asked NAR general counsel and she answered. So many of the specific ways you should approach the business, cooperative compensation.
What is steering?
What is steering? Exactly. And then maybe most importantly, like, why, if you're not following these new rules, you could be creating substantial risk for yourself way beyond what you know. And you definitely don't want to miss that part. This will help you in your business. You need it. Put it in your ears, kids.
And part two is going to cover buyer rep agreements and touring agreements. So watch that as well.
Word.
Lesley, welcome to the show. We are very excited to have you here today.
Yeah.
We're going to be doing, for viewers and listeners, a 2-part podcast with Lesley.
Have we ever done a 2-parter? I think this is our first 2-parter.
Yeah, you know what? This is our 2-parter.
Dang, Lesley,
haven't done that before.
You must be a big deal. Coming in hot with a 2-parter. Sorry,
she's
go
like,
ahead,
I get to talk about legal stuff in 2 different podcasts. Yeah.
Yay.
So,
yeah.
But to give a general background, so Lesley is the general counsel for the National Association of Realtors, and she's graciously accepted to come on here and talk about a variety of different subjects for everyone. This first part, we're going to cover a general legal update, sort of where things are in the landscape now that it's 2025 and we're turning a page. I still feel like it's just one day later. General practices that we need to cover. I have a lot of questions around that. And then cooperative compensation and concessions. Then part 2, so everybody's going to stay part for that. We're going to cover buyer representation agreements, touring agreements, what you can do and can't do. So it's going to be really good content for everybody to kind of clear the air and set the foundation. Lesley, that was my intro. Thank you for being here. We really do appreciate it.
Yeah, for
Thank
sure.
you for having me. Of
course. We're going to dive in because we don't get, we would love to have hours with you, but we don't get all of that. So I'm just going to dive into some real quick questions on general legal update, just to set the foundation. There's a lot of confusion going on in this process and none of us are lawyers. So I'll start with this. The settlement has been approved, but there's multiple appeals that are being filed. Can you just start with, like, what does that mean? How does the process work, this appeals process? I don't think most people don't understand the legal system. So give us kind of the general landscape of that.
Yeah, absolutely. So I want to start by emphasizing what you said, which is that the settlement was given final approval, and that was given by a United States federal judge down in Missouri. The second thing is that it's very common in settlements like this, in a class action lawsuit like this, that there are appeals. And prior to NAR settlement being given a final approval and appeals being filed, there were already appeals pending related to the brokerage settlements that preceded ours. So that's sort of letting you know kind of the playing field and that this is common. In terms of timing, it could take a year or more for the appeals process to work itself through that process. But in the meantime, I want to be very clear that the settlement is approved. The appeals that have been filed don't change the practice changes that have been implemented or NAR's obligations under the settlement. So practice changes are in effect, and NAR will continue to meet its obligations under the settlement, including by making our first settlement payment, which is coming up in February.
Got it. Okay. So this process goes through, I think it's the 8th Circuit. Am I correct with that, where the appeal goes?
That's right.
Can you give us an idea on what the appeals process looks like, just to help us understand what all of this means? Like, what might that landscape look like for us?
Yeah. So we're at the very early stages of that appeal. So it's a little bit premature to really talk about what that trajectory will be or look like. The one thing that will remain consistent, as we have throughout the process, we will continue to advocate that the final approval was right and should be upheld by the 8th Circuit. But ultimately, if the appellate court, the 8th Circuit, as you mentioned, did decide that there was some error in making that approval, the case would likely return back to the trial judge to try to correct the errors that were identified. And generally speaking, those errors are straightforward, and the settlement could be and oftentimes is approved again. In a more rare case, those changes that need to be made may be more difficult or prevent the settlement from moving forward. And so in that situation, NAR would really be put back in the same place it was before, back filing post-trial motions and back potentially pursuing an appeal of the jury verdict that was reached in the case.
Okay. So in the meantime, and Keith's got a question here, it looks like, but in the meantime, while this appeal is going on, everyone should be just continuing as if this is the new reality. These are the settlement terms. You need to be following the settlement terms, regardless of everything that's happening through the courts. Is that a correct statement?
Absolutely. Again, the settlement is finally approved. Those practice changes were implemented back over the summer. And we're committed to keeping those in place for 7 years under the settlement, or maybe longer. And the appeals don't undo any of that at this point.
Okay. Keith?
Yeah. So, well, actually, that was my question, because I've heard a few times out and about, like, well, this is under, it's final, but it's not final. So I'm going to wait till it's final. So if you're hearing this voice, the views being expressed are the views of Keith Robinson, not NAR or any of its affiliates. Stop saying that. These changes are here. They're here now. You must be adjusting and changing. You actually should have changed it a long time ago. So, like, no, this is the new normal for now. And if that changes in the future, I'm sure there'll be emails and podcasts and communication about that. But yeah.
Keith, I'm really glad that you said that, because it's super important that our members, brokerages, MLSs abide by the practice changes and that they do so in good faith, because ultimately they could lose the benefit of the release and also subject themselves to new potential future liability.
Okay, I want to hone in on that just for a second. So if people are not following the settlement terms, and part of what we're going to do through this podcast, both of them, is to as clearly as we can lay out everything in your understanding of it. If they don't follow that, then they're not covered by the release, and then essentially they could get sued. That's
absolutely. They risk that release that was reached on their behalf, as well as new potential liability out there.
Okay. Right before the settlement was approved by the judge, the DOJ filed their statement of interest, which confused the hell out of everybody 2 days before. So there's been a lot of confusion around that. People confused about what the DOJ wants and should they follow the settlement. So can you give us a little bit of background on what that statement of interest was, what the DOJ had basically stated, and what any of that means from your perspective, or what we need to understand? Okay.
So you're right. The DOJ did have a lot of time to come in, weigh in, make its views known. And they did that less than, I think, 48 hours before the final approval hearing. At the final approval hearing, the DOJ was there. They had the opportunity to speak. The judge even, made a point of that the DOJ had so much time to air its concerns and investigate. And they filed very late in the process, giving the court really limited time, as well as limited understanding. The filing that the DOJ made raised a possible concern. And I think
Right.
that's really important for your viewers to understand that they did not raise a specific concern. So it's not really clear what their concern is. They did identify the written buyer agreements as a possible concern, but what their concern is with relation to buyer agreements is not clear. And as I said, they had an opportunity at the hearing to speak, and they filed their paper, and the judge approved the settlement despite that. So, that's really all I can say about what that filing was. And it really was, again, just flagging a possible concern. But as President Sears and NAR has communicated to members, we have been talking with the DOJ. We've had a productive dialogue. We continue to have that dialogue and will have that into the future to try to understand if there are concerns about really anything in the real estate industry, and to try to find that common ground that they came to us looking for, and also advocating for our members and consumers in that process.
So I guess my last comment to pin this is this, again, their statement of interest has nothing to do with people following the practice changes. They need to continue to follow the practice changes. Again, just
100%.
Okay.
Yep.
Absolutely.
All right. My last question on sort of the general legal update is there's these buyer side lawsuits out there. I think they're called Batten 1 and 2. There's a bunch of others out there as well. Can you give us a background on what those are, the premise of those cases, and sort of where they're at, just so that there are different cases than the sell side ones. So I want to try and get a little bit of details, as they don't get as much press as the sell side cases have, and I want to have people understand what these are and what the differences are.
Yeah, absolutely. So at the same time as NAR has been defending these home seller cases, Sitzer Burnett that went to trial, and we have the settlement now, we also have been defending a home buyer case. So there's a couple of home buyer cases that are probably talked about the most. There's also, as you said, James, a few other buyer suits that have been filed around the country. But the big ones are Batten 1, and that was filed in January of 2021 against NAR and the same corporate defendants as the Sitzer Burnett case. And then in November of 2023, a second purported class action was filed against several other defendants. This one did not name NAR. They're both pending in Illinois, and they have been, now for several years. So in the Batten 1 case that NAR is defending, that case is currently in discovery. They've been moving along very slowly. I will just here mention that NAR was successful in the Batten 1 case in getting the federal antitrust claims dismissed, which is huge. And so now that case is just proceeding on the state antitrust claims and the state consumer protection claims. And so these cases, the buyer cases, are similar to the home seller cases in that they challenge similar rules and policies, and including the cooperative compensation rule that no longer exists, but they challenge that rule and others along with broker conduct and say that they harmed home buyers. So the home seller cases say that home sellers were directly harmed as a result of these rules and policies and conduct, in that they were forced to pay artificially inflated broker commissions. In the home buyer cases, the home buyers claim that they are indirectly harmed because they were forced to pay artificially inflated home prices as a result of the rules and practices.
Okay. So let me simplify this. We were successful, NAR was successful in getting the federal claims tossed. So now it's state. Does that mean that they have to file in each state? Is that how that would work? Help me understand.
Nope.
Okay.
Yeah. So, nope. All of the state law claims are in this one federal case.
Got it.
In Illinois. So there aren't separate cases. All of the state law claims are going to be resolved in this Illinois case.
But correct me if I'm wrong, during the Burnett-Sitzer case, part of the settlement removed a portion of the class by the settlement on the sell side. And correct me if I'm off here, but if you bought a house and sold a house during the class, then you've already been taken care of through the settlement. Is that correct?
Yep. That's right. So the home sellers in the Sitzer Burnett case released any claims they had as home sellers, as well as home buyers, provided that they did so within the class period.
That specific group.
Right. Yeah. And it was a nationwide settlement. So we have a nationwide class of home sellers that released those claims, provided they didn't opt out of the settlement. So the potential class, which has not been certified in these buyer cases, is greatly reduced as a result of that.
Is it just someone who didn't sell a house but just bought a house during that same time frame? Is that
so? If you only bought a house during that time frame, then you wouldn't have been part of the home seller settlement. So you're still in there. So if first-time home buyers, or if you're a home buyer or a home seller that didn't happen to sell their home
first. Gotcha.
So it really reduced the size of the class.
Yeah,
significantly.
Absolutely.
Yeah. Okay. So those cases are out there, and I believe they've been moving slowly because they were trying to see how this outcome of this Burnett Sitzer case was going to occur. And Judge Woods was originally with that. I don't believe she's on it anymore. She
recently recused herself. That's right. We have a new judge, Judge Hunt, who's taken over the case in the last several months.
Okay. So we should expect in 2025 to see more headlines on these cases as they proceed through the courts. Is that a fair statement?
Yeah. I think the next major milestone is the class certification, which will be coming up in the next year or so. And that will be certainly a big moment. But for now, it's a bit quiet because we're just going through discovery. I will mention, because you may see this in the news, that the plaintiffs are looking to add additional claims and state laws claims in the case, which all of the defendants are opposing. And so that's being briefed for the court right now.
Okay. Before we move on, I do want to give myself credit for not making a batten down the hatches joke for the Batten case. And now we can transition to the next question.
You're such an idiot.
I know.
Love you, though. You should see our blooper reels. They're just
it's brutal. It's
all right. I'm going to go to general practices. I'm going to skip around this section for a second, Lesley, just because I've got a lot of questions everybody knows that I have. So I want to start with this first one of, do non-realtor agents have to follow all the settlement terms? Is my first question.
Yeah. So any participant or subscriber of an MLS that opted into the settlement is equally subject to the settlement practice changes, the same as a member, even if you're not a member. It's really based on your participation in an MLS that opted in to the settlement.
Okay. So that clarifies a lot. So if you're a member of the MLS, you're following the protocol through that. There's also been changes even at the state level. I know like CAR made some changes where I forget the number, the bill they passed last year, where you non-realtor members have to do mandatory buyer rep agreements as well. And they were trying to make things easier for consumers to not have confusion around that. So, all right. So let me go through this last one on that, and then I'll come back around to some others here. Do all these settlement terms apply to commercial land rentals? The terms of the settlement apply to commercial land or rentals and other categories?
Yeah, so these cases focus specifically on residential real estate. So it does not apply to commercial real estate or leases. Now, that said, if there is a commercial listing or a rental listing on an MLS that opted in, we know that as a result of the settlement that offers of compensation are prohibited on those MLSs. And so that would apply equally to commercial or rental listings.
Okay. All right. So if it's on MLS, you're following MLS policy. If it's not, then it would not apply in that specific case. Can I get specific here and make sure I'm just very clearly explaining this to everyone so they understand? So if I'm an agent representing a buyer and I'm going to go look at a rental property, they do not have to have a signed buyer rep agreement if it's not on. Okay. Same thing for
and even if it's on the MLS, you don't have to have a signed agreement. That written buyer agreement requirement pertains to buyers, not commercial listings or rental listings.
Okay. Keith, do you have any follow-up on that one? Make sure I covered that. So there's confusion here. I want to make sure I got all that out. So.
Yeah, on the specific ones, I do get questions about the agents receiving a referral from another agent from time to time. But my intuition is you're not actually repping the buyer in that situation, so it wouldn't be required. But
yeah, that's right. Yeah, okay. And so maybe the code of ethics or state law comes into play with respect to the referral, but the practice change and the written buyer agreement is not applicable there.
Okay.
Perfect.
Okay.
All right.
All right. So I've got that. Let's go through. Let's go through some general stuff here too. I want to dig deep in this because there's just so much confusion. So can you talk to us about steering and then give us some examples. And I'm looking for specific examples of what it is, so that people who aren't familiar with it and are unintentionally maybe doing something like this can go, oh, okay, I didn't know that, on both the list side and buy side. So let's start with, what is steering? Give us some examples, etc.
Yeah. So steering, I'll just start off by saying steering is prohibited under NAR's Code of Ethics. But steering is a term that is typically used for a circumstance where a real estate professional steers or directs or pushes, persuades a buyer towards a particular property or even away from a particular property based on the offer of compensation. So, for example, on the buyer side, a hypothetical example of steering would be where a buyer agent only shows or makes the buyer aware of properties that have a certain level of compensation or an offer of compensation on them, or discourages, in the inverse, discourages a buyer from pursuing a property or making them aware of a property because of the commission that they might stand to make on that property.
Okay. What about on the listing side?
Yeah, prohibited under the Code of Ethics, Article 1, our North Star here. Realtors must act in the best interest of their clients and put them ahead of their own. And so very clear that this type of conduct, were it to be occurring, is prohibited.
And what happens? So if somebody was doing that, they're violating the Code of Ethics. So is there a hearing done at the local board? Like, what's the process if that actually was occurring?
Yeah. Any violation of the code, including if there's an allegation of steering, would and should be reported to the local association, who will investigate, put a panel together to determine whether or not a violation occurred. And that member would be subject to potential disciplinary action as a result.
Okay. Can you give us an example of steering on the list side? What would that look like?
Yeah. So a hypothetical example there would be where a listing agent tells the seller that you have to make an offer of compensation or an offer of compensation of a certain level in order for buyers to come, or if they don't, that buyers will be steered away from their property. And again, this type of conduct is also prohibited under the Code of Ethics. But I want to make a point here, though, because I think it's important that we make sure that steering doesn't get confused with real estate professionals working with consumers to help them understand what their marketing opportunities and ways that they can incentivize people to come to their property. So, of course, real estate professionals should be talking to their clients, their customers, about the various options they have that could include an offer of compensation. As part of that conversation, the real estate professional should be telling the seller, like, here's why you may want to consider, here's what it might do for your property. And of course, as a result of the settlement practice changes, the seller has to authorize very specifically their listing broker the ability to make an offer of compensation and in what amount before that's made. But steering and talking to consumers about their options are two very different things.
Right. Saying this is an option that you can do versus, if you don't do this, X, Y, and Z will happen is the difference. Right. Is that correct?
Absolutely. Yep.
Okay.
I mean, it really, look, I've been in and around residential real estate for 26 years now. Like, it should be a conversation that you're having with your client on, and there are appropriate strategies depending on what you're trying to accomplish, and no two clients are the same. And so therefore no two strategies are exactly the same. And it should be this deep, thoughtful conversation that's anchored into the fiduciary responsibility that you have to put their interests above your own. Like, so long as you keep the client as the North Star, this isn't that complicated.
Yeah, absolutely. And this is also how you demonstrate your value, or part of the way that you demonstrate your value is that the options, what might work, why you might want to consider. You can lay it all on the table for your customer or your client to consider and have that in-depth conversation. So your client is fully informed about their options and then ultimately makes a decision on what makes sense for them in their particular transaction.
All right, I got one. So this is the one that I want to, because this is happening a lot. So I want to preface again, as you stated, not showing properties as an example because there wasn't compensation would be classified as steering.
A little bit different. So not making the buyer aware of a property.
Got it.
Based on the offer of compensation.
Got it.
Fair. Thank you for clarifying.
Or moving them to a property because of the offer of compensation.
Okay.
Yes.
Thank you for clarifying that. So then
Lesley,
my question
you're good
is,
at what you do.
Yeah, well, that's why she's general counsel.
Yeah, I'm glad you're here.
She's like, no, objection, leading.
Almost. That word,
so,
not right.
My question was, because this is something that we've had, is if the buyer requests it, to say that if the buyer says, I don't want to see any homes that are not offering compensation, how should we handle that?
Yeah, that's a really good question. I have heard that question many times. So, realtors must make their customer aware of all of the properties that exist that they may be interested in based on what they know, what their search criteria are. The client, the buyer, can direct the real estate professional that they only want to see properties that offer compensation or of a certain level. But in no way should the real estate professional be filtering or restricting what the buyer sees or has access to based on what that offer of compensation is. It's ultimately up to the buyer to decide what properties they want to pursue. But it is prohibited under the settlement and was prior to the settlement for real estate professionals, realtors, to be filtering listings based on that offer of compensation and only showing their buyers certain properties based on that.
Can I get on my soapbox for 30 seconds?
Keith and I are, by the way, we're going to, yeah. I'm pretty confident you'll agree with us on this. So
look, if you've ever had a buyer who told you, I need a 4-bedroom because I work from home, and then you showed them a 3-bedroom with a home office that wouldn't work as a bedroom, right? Like that to me, that's an example of where, sure, the buyer tells you one thing and you listen, but as a professional, you're evaluating all the available inventory and looking for something that fits their needs, even if it's not exactly what they clearly articulated or it's a little different than what they said. And we do this all the time in the industry. And I don't think there's any buyers who go into, okay, any is a dangerous word, but it's very rare for a buyer to go into a meeting with their real estate professional and say, just don't show me something that might fit my criteria if they aren't offering compensation. They don't end up there on their own. And that means you're part of the conversation. So just like, take all of this, and I say this respectfully, Lesley, take all this legal mumbo jumbo and like, understand what you're supposed to do is what's in the best interest of your client. And if you see something, then think, well, should my client see this? And as soon as you think that, the answer is yes. It's sort of like when you think, well, should I disclose? Well, then the answer is yes. And so if you think, should my client see this? Well, there's a very simple answer. Yes. Send it to them. Explain that it may not fit exactly their criteria, whether it's a 3-bedroom with an office instead of a 4-bedroom, or they aren't offering compensation, but it seems like it's the perfect house. Then you tell them about it.
Yeah, and that just makes me think like you and your client, the real estate professional and the client, have a mutual interest, right? It's to get from the search to a successfully closed transaction. So making them aware of options that may not exactly fit their criteria, but
that is literally the job. Yeah. It is literally the job like, I know you only want to live in this neighborhood, but I'm supposed to show you these other ones just so you know. I know you said you only wanted a house with a big lot, but this one's got a park across the street. Would that work? We do this every day.
Yeah. And one last comment, and I'll move on here because I'm with Keith, is if there isn't compensation being offered, just tell the buyer, look, here's the deal. I want to show you every property that's for sale. Let's find the house you want to fall in love with, and then let me do my job and figure out how to make the deal come together. Yeah. We can always ask the seller for compensation. We can negotiate it. I've got tons of ways we can make this work. Agents, don't worry about whether they're offering or not. Just focus on finding the damn house that they want, and then go do your job and negotiate a deal. Like, that's what sellers want to sell their house, buyers want to buy it. We'll figure out somewhere in the middle on it. So,
and James, if I may just belabor this just a little bit, because I think this is an important point. I can't remember if your question is, but anyway, I started out by saying that a real estate professional realtor must make the client aware of all the properties that exist that meet their criteria. The difference is, and we get the question, what about, do I have an obligation to show the property where there is no offer of compensation? So that's where that written buyer agreement practice change, I think, is important. And I want to highlight that because now, as a result of the practice changes, you have a agreement with the buyer that very clearly articulates what they are agreeing to pay you as a real estate professional. And you'll have that before anyone sets foot in a home. So if there's no offer of compensation, then the buyer knows, right? You can talk to them about that. There's no offer of compensation, kind of what you were saying. There's no offer of compensation, but there's options here, right? Like, one is that the buyer pays directly. The other is that the buyer broker calls the listing broker to find out if there is anything, or they write something in their purchase offer, asking for compensation. So all part of a conversation, but realtors are not required to work for free. And so I just wanted to emphasize those points.
Yeah, but your comment's right. You signed a buyer rep agreement. They understood what it is. We're teaching people to have this conversation in advance. Some properties might have offers of compensation, some may not. I'm going to show you everything, and then we'll figure out the house you want, and then let me do my job and figure out how to make the deal come together. That's just what we need to be doing with this. And the comment you made is valid. I try to remind people when agents go, well, I don't know what the compensation is. You did. You signed the buyer rep agreement. Your compensation was laid out.
It's in there now. Yeah.
It's in there. Yeah. All right. So I'm going to ask a couple more on this, and then we'll move to talking about cooperative compensation and concessions. So can buyer agents call a listing agent and ask if the seller is offering compensation?
Of course. Yep. That's still an option.
I'm just going down the list of stuff I've got. So let's see. I think we just kind of talked about this. One of them was, what should you do if the seller's not offering compensation? I'm pretty sure we just covered that. We covered those pieces there. I don't really have anything else on the general practice. Keith, do you have anything on follow up with this?
I got one more that I've just seen in the amazing chat rooms of residential real estate. Are we allowed to ask to see the buyer rep? If I'm a listing agent, am I allowed to ask to see the buyer rep agreement that an agent has with their client?
Yeah. So as a real estate professional, you should not share the agreement with anybody, or especially your competitor. There's confidential terms in there that are really important to the negotiation and the strategy for your client. So no. I do understand that some state laws may have requirements. So there's always a caveat that state and local laws apply. You should be familiar with those and whatever obligations you have. But as a general premise, no, there's likely a confidentiality clause in there. And you don't want to disadvantage your client by sharing that information with the person on the other side of that negotiation.
Perfect. Thank you.
Goes the other way too. So buyer agents shouldn't be calling the listing agent asking for a copy of the listing agreement as well. Right. So, okay. All right. Let's talk about cooperative compensation and concessions. And we'll wrap up on this for part one. And then, as I mentioned, everybody, there'll be a part two. We'll talk again about buyer representation agreements and touring agreements. So you answered this, but just for repeat, can brokerages still do cooperative compensation?
Yes. Cooperative compensation is still an option. Just want to emphasize that it has to be a discussion and a conversation between the broker and the seller as to whether or not the seller authorizes the broker to make an offer of compensation. And so that's an important piece, but definitely still an option, but also an independent business decision for brokerages to make. Nothing requires it. Nothing sets any amount. It's a conversation with the seller and an independent business decision for brokerages to make. All
right. So you've mentioned this a couple of times. I want to make sure I'm helping explain this. It's a conversation with the seller, and a conversation could be, there are a variety of ways we can do this because we're going to talk about multiple things here. So one is you can offer compensation. We can do it X, Y, and Z where we split a number, whatever it is. Okay. Option B is we could do a concession. So the point is you can have a conversation. You're letting the seller choose which way they want to go, and you're not influencing them to make one of those choices. Is that correct with my statement?
Definitely. You want your client to be informed. You want them to know about their options. You want them to have information that you have as a professional and experienced real estate professional in the market as to the various ways sellers can try to get their home sold as quickly as possible. And All
right. So my follow-up then is, if the listing brokerage doesn't allow cooperative compensation, so as a policy, because you mentioned that some brokerages don't, and there are many of them out there, and everybody knows publicly, we don't do it at our company either. But can a seller offer and advertise buyer brokerage compensation where they pay the buyer brokerage directly? So, okay.
One of the options, just a caveat being, that cannot be communicated on the MLS, similar to an offer from a broker to broker. But yes, still an option.
Okay, so just so I'm pinning that for everybody, if the broker isn't doing cooperative compensation where you're collecting and remitting, or you're sharing part of the compensation, another way to do it is the listing broker is charging their fee for what they charge, and they're giving these options to the seller. And one of them can be is that we're not doing cooperative compensation, we're not sharing compensation, but you can still advertise X as a fee to the buyer brokerage, and then essentially that's just being paid through the closing process. Did I get that right?
From the seller.
From the seller directly.
Yep.
Okay.
Yep.
Okay. So then that moves me into the next one. Can a seller offer a concession to the buyer to help with closing costs? I think there's a lot of confusion around this. So
same thing. Concessions continue to be an option. Those can be communicated on the MLS as long as they are not limited to or conditioned on the retention or payment to a buyer broker. But definitely still an option, but they can't be conditioned, as I said, as another form of just simply paying a buyer broker. I want to mention just here, though, that MLSs are different. And so there is local discretion as to whether or not an MLS has a concession field and allows for that transmittal of information, but definitely an option on the MLS with that caveat I mentioned, or off the MLS.
Okay. And then the only thing about concessions, it's just more formality, is there's obviously IPC limits that could be affected with that. So, and I just want to be clear, concessions would be done to the buyer, and it would be allowed the buyer to pay closing costs. So it's up to them how they want to do things with that particular fund.
Absolutely. Yep. Exactly. How the buyer wants to use those and apportion them.
Okay. Keith, did you have any follow-up on that before I continue on?
I do not.
I'm giving you a spot. Okay.
No, yep, we're good.
So we talked about this. Cooperative compensation is not allowed on MLS, correct? For any NAR governed MLSs, I should be very specific there. Is that a correct statement?
Any of the opted-ins. So that could be association-owned or independent MLSs that opted in.
Okay,
so any MLS that opted in.
Any MLS that didn't may still be doing that, and you need to talk to your MLS specifically about what their policy is.
Yeah.
Okay. Let's get into the gray area, because why not? Where can agents advertise cooperative compensation if they are still doing this practice? So where can they do that?
The bright line is not on the MLS, but you can advertise off the MLS, a sign in the yard, on your website, as long as it's for your own listings and not other brokers' listings. As long as the offer of compensation they're advertising is only for the broker's listings, your broker's listings, and not another broker's listing.
So the people who tilted up very quickly those, hey, I know what we'll do. We'll just start a website where you can search by address, and then we'll just all sort of, put our stuff there. Yeah, that's
risky. Don't
stop trying to work around it. Just embrace it and embrace the change. This is here to stay.
But if you have James Dwiggins' website, you can advertise James Dwiggins'
.com.
offers of compensation.
It's a very popular domain name, by the way.
Exactly.
It is. Probably.
So, but you just can't advertise for others. And phone calls, texts, all those old-fashioned ways of communicating also work.
Yep.
I'm just trying to make sure everybody's clear, and we're again just getting foundation. Would you advise? I know you're not counsel for everybody, but best practice would be not to be doing anything where you're sharing compensation where competitors are in the same space. Is that a fair statement? That
is a fair statement. Yep.
Okay. So,
so open Facebook groups or whatever, where everybody hangs out, or you can't, start a new Facebook group that's like St. Louis real estate commissions and then post them there. When you're trying to work around it, stop. This isn't that great, really.
The whole point is, we're not trying to circumvent the practice changes. We are trying to implement them in good faith. And that is definitely an example of a risky proposition and way to get yourself into potential new legal trouble.
All right. So social media stuff, when I've got an ad for my listing, post it there. It's just that ad for that listing. It's not being aggregated anywhere. My flyer, I can do it on, I can send it to somebody in an email, but not like a group of competitors. Just do it in an email if I'm sending to somebody who's asking about the property. Basically, property specific marketing is fine. Anything that is about competitors in a shared environment is risky. Compiling the information
with other competitors. And if you're part of any of those Facebook groups, should they exist, I would leave. I would make it known that I'm leaving, that you are not participating in that activity. Absolutely.
Okay. I almost want to repeat it for the third time, but I think I got that across. So, all right. Is there, this is a good one. Do the same rules apply if it's a seller direct compensation payment to the buyer brokerage? Meaning we're not doing cooperative compensation, but the seller is advertising a fee that they want to pay the buyer brokerage specifically. Do all the same rules apply?
They apply. Non-MLS, but other places, fine.
Okay. And just not aggregating still as well.
Yep.
All right. We covered that one already. Let's talk about what are some of the things listing agents need to be doing when working with a seller. Like you've got goals that you guys have done, like to-dos and don'ts lists that you put out. By the way, we're going to put all those in the notes. I don't think people have seen these, and they're really good. I've shared them on social media. Can you just give us some of those like to-dos and don'ts that maybe we haven't covered that they should be paying attention to? And for everybody to know, we'll link them in the show notes so that people can download all of these documents as well.
Yeah, I mean, I think we've hit a lot of them. So some of what I think I would offer here is sort of a re-emphasis of things that we've talked about.
Okay, great.
The first thing I would say is clearly and frequently and often demonstrate your value. Showcase why the consumer chose to work with you, a real estate professional, a realtor, and the unique value that you have. So that's super important because that gives the consumer, the client, insight into what they're paying for, right?
Sure.
They understand the work, the hard work, the hours, the expertise, the years of experience you're bringing to the table. Super important. And we've been saying that for years, but it continues to be true and even more true as we move forward. The second thing I would offer is to make sure that your seller, any client really, but here we're talking about sellers, I think, that they understand the home selling process. Again, that's part of your value. That's what you are here for. That's why they've hired you. And so educate them. And this is a good opportunity for me to plug NAR's website, Facts.realtor.
Yep.
That's where I think the MLS do's and don'ts that you have referenced exist, along with all of our many resources relating to around the settlement. And our new consumer guide series, which we've been putting out almost on a weekly basis. Those are intended for our members to take and use and give to consumers to help educate them, to help them on this journey and help them understand the various aspects and the complexities of the transaction in a way that is really digestible. So use all of those tools to help your...
and can they copy the text and put it in their own design?
Yeah.
You guys are like free, go, take it, use it.
Yes, we want you to be successful and we want consumers to be successful in this process. And then the third thing I would offer here, we've talked about it many times, but it really is the North Star, your guiding light. It's Article 1 of the Code of Ethics. As realtors, you have an obligation to work in your client's best interest and to always put them above your own. And so I think if you keep that in mind in every decision and point in the transaction in your work with consumers, that will keep you moving in the right direction. It really is an obligation that realtors take seriously, and that's what sets you all apart from other real estate professionals and will, I think, keep you moving on the right path and out of potential risk and liability.
Okay. I think it's a good way for us to wrap. I'm going to add a couple pins here. Keith will as well. Just to reiterate one more time, we've got part 2 coming out where we're going to cover buyer representation agreements. This is where we're going to get really specific. There's just a lot of confusion around it in touring agreements. So watch for that. We'll have a link to that as well. I just wanted to make a comment real quick that you guys have done a really good job, especially with these consumer guide series that you've done and the to-dos and to-dos and to-don'ts. I don't know the word, whatever.
It's fun to say.
I know. I would really encourage all the listeners and viewers to go download these things and read through them and then take that content and incorporate it into your buyer and seller presentations. There's really good stuff in there. And if anything, you're educating the consumer, you're raising questions they should be asking you, which makes you look more professional. Like you should go through this content. There's really, really great stuff there. I've seen a lot of buyer and seller presentations, at least recently, from agents, and they're just lacking. So really use that as a guide to update those things. Keith, you want to throw in the last word?
Yeah, I'll add this. I know there are many, I feel a little like we've been, not Lesley per se, but definitely myself and maybe a little bit James, we've been scolding the industry a little for the last 40 minutes. And I know that there are a vast majority of very well-meaning, well-intended real estate professionals who are just trying to figure out how to serve their clients. And then some random ass trainer comes in and tells them the exact wrong thing to do. But that's the first that they heard. And so that's what they go out and think that that's the correct way to do it. This isn't the time to do that. This is the time, like, you might disagree with something James or I say, fine, go to the source, go to the do's and don'ts guides, go to the source to figure out the right approach. This isn't one where the last person you talk to is right. This isn't one of those situations. This one's big enough, a structural change that's significant enough that you need to go to the source to figure out the right way to approach it.
Lesley, you want to add anything else before we wrap up this first part?
No, I think just on what Keith was saying, Facts.realtor it's called Facts.realtor. So you're going to get the facts there. Yeah. And you should be talking to your broker, as agents, be in touch with your broker, make sure that you're aligned with what the practices are in your particular company, and Facts.realtor. But no, thank you so much for having me and for having this conversation.
Good. We look forward to it. We'll do part 2 very shortly. Thanks, Lesley, for being here. Everybody stay tuned for the next episode. Yes, we want you to subscribe to this podcast, but the good news is if you subscribe now, you'll never have to subscribe to any other podcast ever again.